Law Update. It's episode 192, and we're in July of 2026. Here we go. Hello, everybody, and welcome to another episode of Entertainment Law Update. From Los Angeles, California, I'm Gordon Firemark.
And from the Dallas-Fort Worth Metroplex, I'm Tamera Bennett.
And we are so glad that you are here with us for this episode. This is our podcast by us, entertainment lawyers, about entertainment law, where each month we round up the notable cases, news, and information in the field so that we can keep you informed and hopefully a little bit entertained. And first off, we just want to say we do welcome your feedback, your reviews, all that kind of stuff. You can give us feedback on entertainmentlawupdate.com. There's a little tab on the side of the screen, a little voice widget that you can use to give us a message, or just send us an email at entertainmentlawupdate@gmail.com. And let us know what you think about the show. And please tell your friends and help us grow. We appreciate it. So, Tamera, what's new with you in your world?
Well, it's a busy world in the Dallas-Fort Worth Metroplex. I've been blowing and going and got a full house as of last night.
Oh, wow.
So
Okay.
kiddo's home for a little bit.
Yeah.
And as we were chit-chatting a little bit, it is FIFA football mania in the Dallas-Fort Worth area.
The world right
FIFA
now.
fever. That's right. Because I think the Dallas Stadium, which is actually the AT&T Stadium, and not in Dallas, I think is hosting the most games out of all the stadiums, if I have that correct. So anyway, it's been fun as not really a soccer fan, but I think we're either going to go to a game this weekend, tomorrow, or go to one of the fan zones so we can be in the FIFA fever.
I've heard that the tickets to games are colossally expensive, but
they are a minimum $600 for a ticket.
I'm not
so
enough of a
fan
sports
zone. Yeah, fan zone is sounding pretty good to go hang out. I had really wanted to hang out when the Netherlands team was here, but it didn't work with my schedule because they just seem like the most fun fans of any group. Well, we even had to close one of the bars because the fire marshal closed them down because they were 3 times over
capacity. Oh, wow.
Capacity. So
well, before we go to the quasi-legal side of things related to Viva, I just want to mention, I don't know if you've heard about what's going on with ranch dressing and the...
Oh my gosh, yes, go ahead. So the world knows.
So, for decades now, Europeans in particular have sort of made fun of Americans and our love for ranch dressing as a topping and as a dip and all those kinds of things. But what's happening with the visitors to the U.S. Who are here for the soccer matches, the football games, they are loving ranch dressing and trying to take it home with them. The TSA stations at the airports apparently have stack upon stack of confiscated bottles of ranch dressing. So much so that Kraft has now started bottling it in 2 or 3 ounce bottles so people can take it home.
Yeah, and I think it's UPS, DHL, FedEx, one of the delivery services is shipping your ranch dressing for free or something.
So maybe Kraft will maybe this will be an opportunity for all of the brands that make ranch dressing to get into the European market, which I believe is pretty tough, but who knows? They distribute their other products there, so we'll see what happens.
That's right, and everything in Europe is sold in teeny tiny bottles.
Yeah. Who would have thought?
So that makes sense.
Who would have thought that a soccer tournament would lead to those kinds of commercial opportunities and in the European.
Well, and it ties into the brands that are officially associated with FIFA and those that are not. And I don't think Kraft or Hidden Valley, which is Kraft, I think. I don't know that any of those are official sponsors, but yet they have been able to grassroots really bring their branding to the forefront.
Pretty wild, pretty amazing. I
Yeah.
guess it shows that hosting these kinds of events can be really good for not just the local economies, but also, for businesses more generally.
Yeah.
And yeah,
Well, I know you guys have the Levi
I think
Stadium,
that's up in the Bay
which
Area, actually, but
it's in the Bay
Northern
Area,
California.
which is now the Bay Area something something stadium
Yeah.
because they've had to remove FIFA required all of the removal of the branding from the
Yeah.
stadiums. And I know Levi's has maximized that by putting a white banner across their brand on social media and several other stadiums who've had to cover their branding. That entity that has that sponsorship is really maximized it as a non-official
Yeah.
sponsor, and it's been kind of cool to watch them
Well,
do
Levi's in
that. I mean,
particular has really sort of made the most of it by customizing the shape of the cover that they put over the logo so that you can still tell it's the Levi's logo.
oh yeah, super smart. I mean, here at ours is AT&T
Yeah.
Stadium, and they've just covered it up. And I know Mercedes-Benz was the only one that didn't have to cover it because the Mercedes-Benz logo is actually built into how the roof
Oh,
mechanism
that's
works or
fascinating.
somewhere.
Yeah.
Yeah, somewhere on there. And then, we've had things in the news here in the Dallas market, trying to stop those
Mm-hmm.
infringing t-shirts and hats and mugs and other things.
And there's also the situation where I guess at FIFA's request or something, there were some murals that were painted over also in the Dallas area.
So, yeah, so this is really interesting. It's FIFA has been named in the
Mm-hmm.
lawsuit, but FIFA is saying
We didn't
we
do it.
didn't ask the city of Dallas to do this.
Mm-hmm.
So, a large mural encompassing multiple sides of a building in downtown
I've
Dallas
forgotten
has
the
been
artist's
painted
name, but he's
over.
sort of famous for
I
these whale
Ocean
ocean. Yeah.
whale murals, and it's in close proximity to our aquarium
Mm-hmm.
in Dallas. And anyway, he's bringing a VARA
Yeah.
action naming FIFA, I think the city of Dallas, the owner of the
Mm-hmm.
building. And maybe it's just getting traction because FIFA is named. They may not be a
Well,
appropriate party. I'm
yeah.
I'm unclear on that. So
I think Discovery will determine whether there was
right.
any correspondence that said, no, we really don't want that visible during, who knows. I can't
Well,
imagine
and
why
they've
they
only
would, but
and the other thing is if they were going to do it, they would have painted over the whole thing before
mm-hmm.
it started.
Yeah.
And it's not completely covered.
Oh,
But anyway, it's been fun to
yeah.
be a part of the fever and also look at it from a legal standpoint as to the different things that are going on in the area.
Yeah,
So
yeah.
it's been kind of cool,
That
even
is
though
cool.
I don't understand all of the rules, and I'm glad the ties are over. So
all right. Well, let's get into our
let's get into real work. But we thought it's timely. We need to
yeah.
talk about it because it's only every 4 years.
Right.
And when will it be back to the U.S.? I don't know.
Yeah. Well, let's talk about our first case that's in our rundown here. It's a question of fair use and when is it okay to reuse something that was filed in a court pleading. The case is Olson versus Brand Woodward Law LP in the District of D.C., and it addresses this intersection of copyright law and the public nature of judicial proceedings. The district court held that filing a copyrighted work on a public court docket does not place that work into the public domain or eliminate its copyright protection, and also ruled that the defense of fair use can't be resolved at the pleading stage because it has a fact analysis that's important. So Lindsay Olson is a jury consultant and owner of a research and analytics company. She prepared a 27-page jury attitude report. This is in April 2022. And it was prepared at the request of attorneys representing two of the Oath Keeper defendants in the January 6th prosecution. It concluded that there was a widespread community bias in the district and justified transferring the criminal case to another venue. And she was paid, I assume Lindsay is a woman, but I could be wrong, so forgive me if I am, was paid $30,000 for preparing the report, which was subsequently filed publicly on the court's docket as part of the venue transfer motion. Well, several attorneys representing other January 6th defendants later downloaded that report from Pacer and attached complete copies to it in their venue transfer motions, and never obtained any permission from Olson or licensed the report or so on. So Olson subsequently registered the copyright and filed an infringement action against the attorneys and their law firms. The defendants moved to dismiss, saying that the claims were untimely because of statute of limitations, that the Olson was barred by prior litigation that actually involved a different report, and that the report was not copyrightable, and that the public filing eliminated copyright protection, and ultimately that their use was fair use. The judge in the case, Beryl A. Howell, rejected those arguments, denied the motion to dismiss, and broke it down like this. First off, copyright protection is not lost or waived merely by filing a work in the court. Public accessibility and copyright ownership are separate issues, separate concepts, the court said. And while judicial records are generally open for public inspection, the court said that doesn't mean that they're not still protected by copyright. You don't waive your rights. So she reasoned that, the judge, I should say, reasoned that accepting the defendant's position would effectively eliminate copyright protection for every photo or book or song or expert report or any other kind of creative work that gets submitted in part of a judicial proceeding. So basically saying, look, the public right is to inspect those things and reference them, but not to reproduce and redistribute them. Kind of a fine line here, but I think it's an important one. The court noted that Olson didn't challenge the right of the attorneys to cite the report, to point the court's attention to it, or even summarize its conclusions, but really just the reproduction was a factor. Next up, the court looked at fair use and decided, can't decide that here. It's not in a motion to dismiss because there are too many, it's a mixed question of fact and law, and it requires discovery. We need to find out whether or not the use is justified, whether it's transformative, how commercial the use was, the name, amount, and substantiality taken, all the four factors. So the court said can't dismiss on that basis right now, and then rejected all of the other defenses here. There was a statute of limitations defense, and the judge relied on the discovery rule, saying, hey, that still governs in these cases. When should Olson reasonably have discovered the alleged infringement? That's a factual question. Can't do that here. And collateral estoppel was out because that earlier litigation was a different report, different parties, and materially different facts. And ultimately, as far as copyrightability and ownership, the registration stood as prima facie evidence of that, and so the case moves forward. Now, this is not a final determination, doesn't determine whether there was infringement. It was merely not going to dismiss at this stage. And so those other questions remain open. But it's important guidance, I think, that we think about, attorneys, expert witnesses, consultants who submit their materials in these judicial proceedings we need to, if you want to reuse them, you better get a license, get permission. And that finding that a public filing doesn't extinguish or modify copyright protection is an important one. So pretty good.
Yeah. And I wonder how often is this happening every day? Copying, say in a specific relationship to the expert report or something like that, where it's just been fully copied and attached and said, here you go, court, here you go, judge.
Yeah. It raises another interesting question of what if you wanted to introduce it as an exhibit at trial? Would that...
Well, you would have to be able to. That would have to be fair use.
I would think so. But, these consultants make their money by rendering these reports. And so... I could see this case being cited to say, hey, wait a minute, you don't even get to use that document. I mean, you can refer to, well, how do you point the court's attention to it without entering it as an exhibit? So
that is interesting because imagine you represent the plaintiff, whichever, pick a party.
Yeah.
The plaintiff's expert, and you're like, oh my gosh, this is not the expert report we wanted. It is not helpful to us as the plaintiff, so we're not going to introduce it. But you had to disclose it. as part of discovery.
Mm-hmm. Yeah, if you're aware of it and if you've done the research like these.
I think it gets in by some kind of, questions through
Well, then there's the question of how do you
witnesses.
authenticate that document without bringing that expert in to testify about it,
Authenticate
and
it.
that is going to require you pay that expert a fee if they're an expert.
Oh, yeah.
So
Yeah.
maybe that's the workaround.
Interesting. This is right. I'm sure our litigation colleagues
I was just going to say we should reach out to Brent Turman or some of our other friends and say, hey, what would you do?
Yeah. Hey, Brent. Yeah.
If you're listening,
what would
Brent,
you do? Did you
chime in? Give us a
That's right. give us a call. You got both our numbers, so we'll get that from you. So interesting. But of course, I mean, you're doing a copyright infringement case, and so you've got to put the photographs into evidence or the music into evidence. That does not remove the copyright or copyright protections.
Right.
That's common sense. So,
well, let's
good judge. You used common sense.
Yeah. Let's shift gears and get a little Funkadelic. What do you say?
I'm always down for a little Funkadelic. Super fun, interesting case, probably because it deals with copyright grant terminations, which is always something I enjoy talking about. But the plaintiff is the estate of Bernie Worrell. He's the legendary keyboardist, arranger, composer, I would say creator of sound recording copyright work that helped to create the distinctive Parliament Funkadelic sound. The defendants are George Clinton and his company Thing Inc. We're going to refer to them as Worrell and Thing throughout this. And it really kind of stems from a 1976 agreement under which the plaintiff Worrell assigned ownership of certain sound recordings to Thing in exchange for royalties. Over the years, the parties kept suing one another, or at least Worrell kept suing for his unpaid royalties. And interestingly enough, the agreement, document, assignment, whatever we want to call it, was signed by Worrell, but it was not countersigned by anybody on behalf of Thing or George Clinton. And both sides consistently, through all of these royalty disputes, treated the agreement as valid, and there were settlements related to the royalties, and then there were disputes over the settlements related to the royalties. But Worrell passed away, and in 2019, his estate sued, saying there was a breach of the agreement. And interestingly enough, the defendants took the position that the contract was never enforceable, so it wasn't valid, because Thing had never signed it. So that caused things to change. And in 2022, the estate filed a deck action saying, well, if the agreement was never valid, there was no copyright assignment, and that means Worrell is a joint owner in the copyright for everything he created or participated in as part of Parliament Funkadelic. So that's a big change from you owe me royalties to now I'm a joint owner and we're going to have to do some accountings here. The district court dismissed the copyright claims, though, saying it was barred by the statute of limitations, reasoning that any ownership dispute should have been apparent and should have been filed much earlier, decades earlier. But the Sixth Circuit on appeal disagreed. They said that there's no way that the estate or Worrell was on notice as to this dispute to ownership until Thing said there was no valid contract. So that's when that claim arose. And the court went on to make some distinctions between royalty disputes and copyright ownership. Again, for decades, the parties had disagreed over these royalties. And again, this agreement was kind of couched as an exclusive artist-producer agreement with this assignment language and royalty payment language in it. But the Sixth Circuit disagreement over payment does not communicate that an author's ownership rights are being denied. The court reaffirmed that a copyright ownership claim does not accrue until there has been a plain and express repudiation. And that's what happened when Thing made that claim in their pleadings or court filings. The existence of a dispute over a contract may not necessarily alert the author to a challenge to his copyright. So just because they spent decades disputing enforcement of the royalty payments, it doesn't mean that he or his estate were on notice that he should have been claiming copyright ownership in the work. So anyway, Worrell, this case shows us that the dispute standing alone does not necessarily trigger the Copyright Act's 3-year statute of limitations for these ownership claims. There needs to be a clear and unequivocal repudiation, which is what occurred, and that didn't occur prior to that time. A reasonable person in Worrell's position could believe that ownership had already been transferred under a valid agreement, and that only the disagreement was related to those unpaid royalties. So again, it was the defendant's own litigation strategy that created the ownership dispute. It supplied the factual basis for the estate's claim, and the court could find that ownership was not actually repudiated until 2020, when the defendants first denied the validity of that proposed assignment agreement. It raises this issue under Section 204A of the Copyright Act as to what is a valid transfer of copyright. And it's really, in my mind, important to say that I'm going to read 204A. A transfer of copyright ownership, other than by operation of law, is not valid unless an instrument of conveyance or a note or memorandum of the transfer is in writing and signed by the owner of the rights conveyed or such owner's duly authorized agent.
Which we have here.
A copyright assignment must be signed by the assignor. There is no requirement that the assignee execute the document. Now, do I always like for the assignee to execute the document? Yes, because I think it's clear what's going on, but there is no requirement for the assignee to acknowledge, agree, accept, or do anything else.
And as I think about it, I've seen short form assignment not an agreement. It's just an assignment, right? I hereby transfer my stuff to you. And the you doesn't have to even, I've seen them without a signature line for the assignor. The assignee.
That's right.
Presumably there's a longer form contract that's a part of the transaction, but.
That's right. And so as to the defendant's argument, there wasn't a valid agreement. For purposes of other terms and conditions separate and apart from the assignment,
yeah, then you do.
Clearly, they've acted for decades under a valid agreement, but
and the reliance
they shot themselves in the foot.
Yeah.
They shot themselves in the foot because the document on its face may have actually been a valid assignment.
Now, Now, the timing here is an interesting one as well, because 1976, prior to sound recording copyrights being covered under federal copyright protection, yes? So
that's correct. And so it would have been, in my mind, state law would have covered, and again, state law covered the contract portion as well, the assignment of those rights. Because there was no federal protection. And this was a document dealing with his contributions to sound recordings. I mean, there may have been, I didn't go look and see how copyrights are filed for the songs, if he was listed as an author on some of these songs that are the underlying work, but it dealt with his contributions to the production. Yeah. So,
well,
I think that's an interesting thing, academically to ponder, and it may not matter for the litigation purposes.
And interestingly, Section 204 is part of the 1976 Copyright Act. I wonder.
That's right.
Didn't go look, obviously, but I wonder how that would have been treated under the 1909 Act, because this contract was executed prior to the effective date of the 76 Act. So
that is true.
I wonder, maybe one of our volunteers can go and look into, was this Section 204 handled in a similar way in the 1909 Act about how assignments were to be executed. I don't think it ultimately it's contract law, but
yes, and I'm somewhere behind me on my bookcase is my 1909 Act.
all right. Well,
I won't do it while we're podcasting.
We'll
I'll look
amend
after we're
our thinking in the next
we'll
episode.
amend to see if it actually changes anything. But anyway, as to joint authorship, then the defendants went on to say he was merely a performer. The Sixth Circuit concluded that the record contained evidence of far more extensive creative contributions. He arranged, well, this is where it says he arranged compositions. That would go to the song side of it. But he developed musical structures, created synthesizer parts, participated in production decisions, overdubbing. He helped shape the finished recordings. So rather than resolving those questions as a matter of law, the court held that a jury should determine whether those contributions were sufficiently original to create, and whether there was intent to create a joint authorship. So again, we've kind of talked about this was really dealing with sound recording, but I think it's kind of overlapped with his underlying songwriting credit that needs to be looked at as well. In the end, the Sixth Circuit did not determine whether the estate owns any copyrights. Instead, it held that genuine disputes of material fact remain regarding the statute of limitations as well as this joint author claim. So again, I guess our reminder is you need to always look at these disputes as both a potential for a contract dispute and a copyright dispute, because contract disputes are different, or compensation disputes are different than ownership disputes. But sometimes it's going to sound in copyright and sometimes it's going to sound in contract. And you need to figure out which one that's going to be, or if it could be in both, because your remedies and your statute of limitations are going to be different.
And think through your defense strategy in a situation like this so you don't open up a can of worms.
Well, they did. I mean,
think, yeah. Well, I think all that prior litigation certainly signals in all the lawyers' minds at first, at least, hey, there's no disagreement over who owns this stuff. But apparently there is. So anyway.
Yeah.
Well, here's an interesting one coming up. You have something more to say on that?
Well, no, I'm just going to say this has blown my mind, but proceed.
Well, I'm sure we've all heard the radio ads, the TV ads for Kars4Kids. I'm going to spare everybody the pain of hearing me sing the jingle, but everybody knows it. 1-877-Kars4Kids. Donate your car today, essentially. The TV version of the jingle features children 8 to 10 years old playing instruments and repeating the whole 4-line jingle over and over again. And the case is here involving a plaintiff, Bruce Puterbaugh, suing Kars4Kids LLC because he donated his 2001 Volvo XC, a non-functional 2001 XC, to the organization, and testified that he then felt taken advantage of after he discovered that the funds didn't stay in California where he lived, but that they actually supported a northeastern New York, New Jersey-based specific religious mission organization. He asserts that he thought the car would benefit underprivileged kids from all over the U.S., specifically kids in California, given that that's where he was and that's where the donation was happening. I think that's a little peculiar. And that he amassed all this information from hearing that Kars4Kids jingle. Well, during the trial, the chief operating officer of Kars4Kids, his name is Esty Landau, testified on several points, and this is sort of revealing. First off, he said the 30-second advertisement, which has been running now for 20 years, 2 decades, doesn't say anything about the charity's specific nature. Next, that the primary function of Kars4Kids is to fund an organization called OORAH, OORAH, where 60% of the funds raised from Kars4Kids go to OORAH, which is dedicated, that organization is dedicated to Jewish heritage and summer camps in New York and New Jersey. 25% of the revenue is derived from California, he said, and Kars4Kids has no functional programs in California, just raises money there. And the organization's primary purpose is not to help economically disadvantaged children. Then we have the experts who presented surveys to the court, finding, and the court didn't care for those. They found them insufficient. But the court found that although insufficient, they were consistent in establishing that the ad lacks any descriptive content regarding the charity's actual operations and relies on assumptions consumers make when they hear the jingle. And that doesn't necessarily match where the proceeds of the donations go. So the court finds that the plaintiff has standing and suffered an economic loss. The court finds that the First Amendment does not shield the defendant in a case like this, and the evidence confirms the hidden facts are true. The vast majority of the funds go to URA, which supports Orthodox Jewish programs in New York and New Jersey and in the Middle East, and there's no geographic nexus to California. The evidence also shows that children, especially needy and underprivileged kids, are not the recipients of the proceeds of the donations. Reasonable consumers not required to be computer savvy, as the website gave more information than the TV ad, and that directs the ad says go online. The ad says call, not go online. I think the defense was saying, hey, all the information's on the website. That should be good enough. And the court then finds that the message that the charity helps needy children is not inherently vague. The name Kars4Kids, the 8 to 10-year-old actors in the advertisement, and the repetitive jingle all serve to reinforce the belief that donations are used exclusively for the benefit of children. And under cross-examination, that COO, Esti Lando, admitted that the organization's primary purpose is to help Jewish kids and families throughout their lives. Evidence also established that the organization funds matchmaking services aimed at young adults, gap year programs for 17 and 18-year-olds, trips to the Middle East, trips to Israel, and that kind of thing. So the court finds that the failure to disclose that the funds benefit adults and families as well as kids, and that the support is contingent on the religious affiliation, Judaism, that's a material omission in the eyes of the court. And a reasonable consumer donating to a kid's charity would attach importance to the fact that their donation is actually supporting adult matchmaking and general family subsidies. So the lawsuit had claims under California's Business and Professions Code 17500, which is false advertising, and 17200, which is an unfair competition law. So I'm not going to get into the exact nature of those statutes, but false advertising is basically also covers any ad content that is misleading or has the capacity, likelihood, or tendency to deceive or confuse the public. And it doesn't require intent. It can be a negligence-related kind of a claim. The court finds that the defendant disseminated public statements concerning the disposal of property, the vehicle donations, that were misleading by omission. And the knew or should have known standard is what applies there. The court finds that the defendant's stated intent to make the ad memorable through extreme repetition, while simultaneously stripping it of all substantive facts, constitutes an actionable strategy of deception. And then on the unfair competition part of the statute, the defendant's conduct violates it under the following three prongs. Because the defendant advertising practices violate the false advertising law, those are predicate acts, basically, for finding of unlawful business practices. It's fraudulent. A business practice is fraudulent under the law if it is likely to deceive a significant portion of the public. And the court says that jingle creates a false sense of a universal, secular, local charity. Okay. The Kars4Kids name, when coupled with an ad that doesn't mention anything about its specific mission, is likely to deceive the public, the court says. And the omission of facts that consumers would find significantly important when making their donation constitutes inherent deception. So the harm of soliciting donations through intentional omissions outweighs the purported utility of the advertising. The public is misled into believing donations aid underprivileged kids in California, when in fact the funds primarily support a separate organization in New York, New Jersey, that benefits only certain families locally and abroad. So that failure to disclose is important. So the court issued an injunction permanently enjoining the defendant from broadcasting the jingle or any variation in the state of California unless there's an express audible disclosure of the religious affiliation and the geographic location of its primary beneficiaries and their ages, specifying whether they aim for kids or families. And any future ads must clearly and conspicuously specify the actual age range of the primary beneficiaries.
So have you heard any ads? Because as of June 4th, the court said the ads may run during the appeal. So I wonder if they've put them back up or not, but I guess it's not quite as permanently enjoined as we first thought.
Yeah, I confess that I don't listen to much broadcast other than NPR, where I wouldn't hear an ad anyway.
Right.
Mostly I listen to podcasts and other kind of online content. Practice what you preach.
Right. So I will tell you, as average Joe consumer,
Mm-hmm.
I had an assumption that if someone donated a car here in Texas, it was going to benefit how I would define as underprivileged children
in Texas.
Yeah.
I don't know that I would have drawn that conclusion necessarily.
But would you have drawn the conclusion it was benefiting children in need?
Yes.
Okay.
I would definitely draw the conclusion that it's children. I would definitely draw the conclusion that it's, that it's to benefit needy kids and their families. I don't know, I can see that. Right. I'm troubled by the fact that the religion is a component of this. I don't think it matters what the organization does support, except that it exceeds the scope of what the ad seems to suggest it supports.
Right.
And I'm troubled because, separation of church and state, is this an establishment clause kind of an argument maybe on an appeal? And it's obviously it's a prior restraint on speech. So we're going to have some First Amendment issues. I think the First Amendment may come into consideration here. Can a court enjoin you from broadcasting something that supports your religious maybe you do need to be better about disclosure. I think that's the real trouble. False advertising is not free speech. So
that's right. So just kind of a little bit of additional information. There's already been settlements in Pennsylvania and Oregon, I guess maybe with the state's attorney for those states. There's a 2024 class action in California pending, and there's an additional 2025 pending proposed class action.
And this is one of those California citizen attorney general statutes where an individual can make the claim, basically.
That's what I wondered, because I went and looked to see, well, what's happening at the FTC? Could I quickly find anything? Because as an individual, we can't bring a claim under the Federal Trade Commissions Act. But
here he actually made a donation, so he does have standing, as the court
said.
Was
right. He had standing. He got his $250 back, and we were considering donating a car. And it's not that I don't have an issue with. I don't personally have an issue with the specific charity, but I do personally have an issue with. I would feel very misled as to where that money was going to go.
Absolutely. So this doesn't indicate whether there was a jury or whether it was I think it was just a bench trial.
I don't know the answer to that.
Certainly, we keep referring to the court fines. So I'm thinking it was bench trial, and I think that's fine. But put it in front of a jury, I think you have a harder case on the defendants in this situation. So
yeah.
Well, we'll see what happens. That appeal, we'll be talking about it in a year or two, I'm sure. So
that's right.
Let's talk about Two Live Crew.
Yeah, we're just doing throwback by throwback by throwback.
Well, and Two Live Crew, a famous party in copyright litigation. But here we have
that's right,
going a different way this time.
We are going a little bit of a different way. And so members of the rap group Two Live Crew attempted to exercise their termination rights under the Copyright Act, again, to regain certain rights in their sound recordings. And the 11th Circuit on appeal deemed their notice of termination ineffective. In 1986, the four members of Two Live Crew, Luther Campbell, Mark Ross, Christopher Wong Wan, and David Hobbs, granted Luke Records, a record company owned by Campbell, their sound recording copyrights and all master recordings that the group made during the agreement's term, which was the year of 1987, with options to extend it through 1990. In 1995, Luke Records, again owned by Luther Campbell, filed for Chapter 11 bankruptcy. And as part of the bankruptcy for the company, sold the master recordings to Little Joe Records, Inc. In 2000, band member Mark Ross individually filed for Chapter 7 bankruptcy. As part of that bankruptcy process, you've got to tell what your assets are. And no one scheduled, administered, or mentioned Ross's copyright grant termination interests, which are contingent, as part of his bankruptcy. They just weren't disclosed. In 2020, 3 of the group's 4 members, including Ross, served a termination notice on Little Joe Records and were met with a lawsuit. Like most record labels, Little Joe Records sought a deck action that Two Live Crew could not or did not terminate these grants of copyrights listed in their termination notice. They argued that Ross transferred his termination interest through his bankruptcy proceeding, rendering the termination notice ineffective because if you have 3 out of 4 filing it, that gives you a majority, which is required under the Copyright Act. If you have 2 out of the 4 filing it, you have 50%, which is not a majority. So you got to have that 51%. The parties then cross-moved for summary judgment about whether Ross lost his termination interest to bankruptcy and to the ability to file this notice of termination. The district court had to interplay Section 203 of the Copyright and Section, 11 U.S.C. Section 541, paren A, paren 1 of the Bankruptcy Code, and said this excluded Ross's termination interest. Well, did it exclude Ross's termination interest from his bankruptcy estate? And the court said no, it did not. The case proceeded to a trial where a jury found in favor of Two Live Crew, and Little Joe Records then appealed. So excuse me, I had that backwards. So the jury said, that right wasn't extinguished. Little Joe Records has appealed to the 11th Circuit, where on appeal, they've reversed the district court's judgment and remanded the case for further proceedings. So again, these notices were going to assume for purposes of our conversation, they were timely filed and met all of the other requirements of a copyright grant termination notice. But the one thing that now the court is saying they did not meet was this requirement of a 51% interest. And they're saying that because they say the bankruptcy code trumps. When a person files for bankruptcy, all that person's interest in property enter the bankruptcy estate, whether it was listed or not.
Yeah,
notwithstanding any...
Otherwise, you could defraud the bankruptcy proceedings by leaving things out. So, yeah.
By leaving things out. So even notwithstanding any provision in applicable non-bankruptcy law, i.e. copyright law, that restricts or conditions transfer of such interest by the debtor, Section 541A1 sweeps into the debtor's bankruptcy estate, 1, all legal or equitable interest of the debtor in property. So even though this was a contingent right, it is a right that got transferred, that existed as of the commencement of the bankruptcy case. So it was contingent, I guess, at the time of the bankruptcy case, but that was still in existence, with some exceptions not relevant to this case. So property that is scheduled but not administered defaults back to the debtor when their Chapter 7 case closes, though property that is not scheduled, administered, or formally abandoned remains property of the bankruptcy state unless the court orders otherwise. So the bankruptcy code prevented Ross from exercising his termination rights as his interest became part of the bankruptcy estate, even though it was a contingent interest. So what does this mean? Because he can't exercise his right, the other two who joined him in the termination can't either. Practice pointer for the creator, the assignor. Don't sign one joint agreement, because we have other case law that says had they each signed an assignment, and I think this was the YMCA case, isn't it?
I think you're right. Yeah.
The Victor Willis case, which was dealing with a song, but each songwriter individually assigned their rights. So if you have one document signed, then that was more than 50% of the interest exercising their right. I go back and forth on that, but anyway, it's something to keep in mind as we advise clients.
Well, and yeah, I mean, logistically speaking, is there something you could do in the contracts that, signing in their individual capacity rather than as members of a partner? I don't know. Is there some workaround for that?
I'm sure.
Rather than having to have 4 contracts.
I don't know. I will say, as this case progresses, I'm going to see if we can invite my good friend Theta Page, who's a bankruptcy attorney, a personal bankruptcy attorney, to join us to talk about this. Because kind of my first note to myself here was, does the bankruptcy trustee have standing to join in the termination? No. I mean, how? They're not a named party in the code, which is also detrimental to the trustee, to the bankruptcy estate, because then they're missing out on that money.
Yeah.
And so I guess the trustees should be subrogated to the assignor, where they would get the money out of the estate. But anyway, the court says we do not address how termination interest should be treated in bankruptcy.
Well, I think another practice point is...
So, yeah, I don't know. I mean, I think the only person who doesn't lose here is Little John Records. But the trustee loses in the estate, and the family. I mean, why would the family be motivated to file it if they know their claim's going to be subrogated to the trustee? But the other guys that are part of this, they're the loser here too.
That was what I was going to get at. Is I think it's an important practice pointer and just a point of consideration for anybody who's a member of a collaboration group of some sort. That if one of the members of the group is declaring a bankruptcy, then it is a good idea, I think, to step up. The other members of the group should step up and at least consider buying any unaccrued contingent interests out of the estate before there's, and maybe even build into the contracts that they have a right of first refusal to do that or something like that as a way.
And I wonder if that would even hold up in a bankruptcy. Well, as far as the right of first refusal, would it be enforceable, or at least maybe they need to be put on notice so they could go in to purchase that asset?
Yeah, I don't know that an automatic transfer of that interest in a bankruptcy would be enforceable, but
I don't think it would.
A contractual right to at least get the first offer. Let's talk to your friend, the bankruptcy attorney. And see
she's a great resource and does a lot of podcasts. So I think she would be great to add to us when this comes back around the next time.
Well, fascinating. I mean, I think for those of us that are representing groups or members of groups, we ought to be thinking about this as something to add in to whatever our transactions look like, just as a way of trying to.
So, I'm going to send her the link when we get posted, and maybe ask her if she has time to just call in and give us some feedback that we can maybe use next time.
Fantastic.
We'll see if we can make that happen.
That's great. Okay. Well, it seems like in the 17-year history of this show, not a year has gone by when the subject of tattoos hasn't come up one way or another, and this is no exception. This is the Kat Von D case that we talked about, I think, a year or two ago. The Ninth Circuit Court of Appeals here in California has agreed to rehear the copyright case between Jeffrey Sedlick and Kat Von D, whose real name is Catherine von Drachenberg. This is the dispute over whether the tattoo she made featuring an image of jazz musician Miles Davis unlawfully copied Sedlick's copyrighted photograph. He sued after she used the photo as a reference for the tattoo. And although the tattoo closely resembles the photo, evidence showed her working directly from the image. The jury found that the tattoo was not substantially similar to the image itself, and that led to a verdict for Kat Von D. So both the district court and the three-judge panel of the Ninth Circuit had allowed the verdict to stand because of the Ninth Circuit's longstanding extrinsic-intrinsic test for determining substantial similarity. And under that framework, the courts concluded that they couldn't overturn the jury's factual finding. The decision now to rehear the case en banc before an 11-judge panel is pretty significant now, because these reviews are pretty rare and generally reserved for cases involving conflicts with decisions from other federal courts, questions of exceptional legal importance — I think that's the hook we're hanging this on — issues likely to attract review by the Supreme Court, or matters with broad consequences beyond the parties. And this case really satisfies all of those. Broad consequences reaching far beyond photography. If creators can't prevent others from making near exact copies of their works in other media, then the practical value of copyright protection kind of goes out the window. It's weakened.
Right.
And this intrinsic-extrinsic test arguably departs from both the text of the Copyright Act and the precedent from the Supreme Court. In the original appellate panel, there was a concurring opinion from two members that stated that the intrinsic test is a judicial creation unique to the Ninth Circuit, that the Supreme Court has never endorsed making an ordinary observer's subjective impression the decisive factor. I mean, isn't a jury decision always a subjective impression? And then courts should instead carefully separate protectable expression from unprotectable ideas when evaluating infringement. So this hearing en banc is an opportunity for the Ninth Circuit to reconsider its approach to copyright infringement. If the court abandons or significantly revises this intrinsic-extrinsic test, that decision could really reshape copyright litigation throughout the Ninth Circuit and strengthen protections for creators, photographers, and so on. So if they leave it unchanged, then it will continue to position the Ninth Circuit as an outlier in this field. So that's pretty significant.
Yeah.
Be interesting to see what happens, and you'll hear about it here on Entertainment Law Update.
And I feel like we've talked about it this year. Was it last year? I feel like it's even been more recently than a year ago, but
this case may have been early in January, February, something like that. I just don't recall.
Or maybe we put it in the roundup, the end of the year cases to watch kind of thing. It just seems really familiar.
Yeah. What do you think about this proposed move of the Copyright Office from under Congress's supervision to the executive branch? Have you heard about this?
I haven't. I can't decide what I think.
Same here.
So earlier in June, the House of Representatives passed H.R. 6028, the, quote, Legislative Branch Agencies Clarification Act, which was presented as a technical reorganization of some government agencies, but contains proposals that would fundamentally change the U.S. Copyright Office. The Copyright Office is responsible for registering copyrights, which we know, but they also maintain records. They are charged with growing the Library of Congress's collection, providing expertise to Congress on copyright law. Over the past 2 decades, the office has become increasingly influential in copyright policy debates that affect free speech, libraries, educators, competition, and everyday internet use. I would say since the 80s, they have probably served in more of that advisory expert role. And I think we discussed this over the last year, as we saw when registers of copyrights became more appointed for their skills and expertise than because they knew somebody. But they have been involved in reports over stop online piracy, AI, DMCA, the Mechanical Licensing Collective, and all of their reports related to that and their rulemaking. But this HR 6028, if enacted, would move rulemaking authority over DMCA Section 1201 from the Librarian of Congress to the Register of Copyrights. It would also sever Library of Congress supervision over the Copyright Office and transfer many librarian powers directly to the Register of Copyrights and make the Register of Copyrights a presidential appointee, which means, of course, well, they do have to be confirmed by the Senate, but then they're subject to change every 4 years at least, which in my mind, obviously, that removes continuity of that position.
And
At the same time, the library,
as well.
It makes it a very political position, which again, when we had these conversations about a year ago, it was a very politically driven office up until the early 70s or early 80s. At the same time, the Librarian of Congress and the head of the Government Publishing Office are moving under congressional appointment. So they would be elected by congressional committee. This separates the entities at a time when some of the largest questions on AI authorship are still unsettled. So it's pulling apart the Register of Copyrights and the Librarian of Congress is how I see that, right? Yeah. And then Librarian of Congress is in the name. So right. They would still be congressional, but the Register of Copyrights would be a presidential appointment. Have I got that right?
Yeah. I'm troubled. This is, part of the overall moves within the Congress and the executive to strengthen the presidential powers. This whole unitary executive theory that's gotten very popular among a lot of groups recently. And I think this is a field where we want a professional in the field to be running and certainly influencing policy on this, rather than someone who, in the worst case scenario, is merely a rubber stamp for whatever the president wants. And that goes both ways. Either party could abuse this. And I guess copyright law is a function of a statute and the Constitution. And I think the makers of the statute should have some say over how the office is appointed and occupied. And
right. I mean, it.
Anyway,
as long as I've been a lawyer, we've always had a Register of Copyrights that, in my mind, was qualified for the job, far superior to my knowledge, anything. I'm not that familiar with who the Librarian of Congress is, although I do believe, since the library is in the title, it should be someone who is skilled and a professional in library sciences, although I know that's not always the case.
I believe
because
that
they're running a library.
It's Todd Blanche, isn't it?
And who is not a librarian, I don't believe.
I'm looking it up as we speak, but
okay,
go on.
Yeah. So anyway, I'll keep talking. I can just keep talking. So, librarians have very specific skills and understanding and things that the average person doesn't have. So in addition to administrative functions of running something as large as the Library of Congress, there is also a method to the madness of how a library functions that we need someone to understand.
So the current library...
Dewey Decimal? I was going to say Dewey Decimal, but that's the extent of my function of the library.
So the current librarian is actually a matter of dispute right now. After the president dismissed...
I thought that was.
Yeah, the president dismissed Carla Hayden back in May of last year, and now there are two people who are claiming the role of acting librarian. One is the principal deputy who had assumed the role back then, Robert Newland, but President Trump appointed Todd Blanche in May of 2025, a few days later. And so the official records list the position as disputed vacant. And both are
Wow.
serving.
Okay. So see, so it was a year ago. It was a year ago, May, that they let go of the Librarian of Congress and Perlmutter, who now has her job back, right?
I believe
the Register of Copyrights.
Well, again, pending all the disputes and whatever. But yeah, I think, yeah, I mean, I think you and I are going to think, and folks who practice in this field are going to think that this is an important office that shouldn't be just going whichever the way the wind blows politically. And you know, for a lot of Americans, it doesn't matter one little bit. But we're in this area of AI, and there's a lot of disputes and policy decisions to be made about how AI will be treated in the copyright law. And I think that this is a matter of utmost importance right now. So if you agree that that's important, I think it's incumbent upon all of us to express our points of view with our congresspeople before the end of the term. This House bill, I mean, the Senate has to do its work too, and maybe a little harder game there. But I think we all have to stand up and be heard on these kinds of issues.
Yeah.
So.
Yeah. And if you think we're wrong, then stand up and be heard that way.
Right. I mean, express your point of view either way, and let the process do its thing. But there it is. Right. Stephen Colbert, no longer on the air on the Late Show. This is a wild story. I mean, the whole thing was wild. More. We can get into the politics behind it, but Stephen Colbert is now off the air. But in his last, one of his last, I think it was the last episode, he kind of thumbed his nose at the network, CBS, and said when the band played the song Linus and Lucy, I think is the title of the song. They played a little portion of the song on air, and then he said, "Oh no, I hope this doesn't cost CBS any money." CBS having repeatedly made their claim that the whole show was costing them money and wasn't really a profitable thing. So, they played the copyrighted music, and they didn't have a pre-clearance for it. So he made his comment, and they tend to be a litigious. The Peanuts music folks tend to be a litigious party as well, and they've sued the federal government for unlicensed uses of the song. So CBS has now agreed to pay the rights holders, to pay a charity on behalf of the rights holders for the use of the song. They've settled with the rights holders whose names are not listed in our summary. Anyway, so they've paid an undisclosed amount to the charity World Central Kitchen, which happens to be one that Colbert has supported and been involved with over the years. So they're paying some money out to avoid being sued for copyright infringement from that last episode. So kind of an interesting sticking his thumb in their eye approach by Colbert. It was amusing at the time, and I honestly thought he was talking about the fact that they litigate these cases and so on. Maybe it was fair use. It wasn't the whole song. It was, a small portion. It was a commentary, but fighting a
I didn't see it, hear it, but based on the information, I was like, if they wanted to fight that for fair use, they could. But I think they put it to bed quickly.
Well, and certainly CBS fighting a fair use case is more expensive than just paying a license fee to a charity.
That's right.
So
at least they look a little okay.
A pragmatic approach from CBS, I guess you could call it. So what about this Watts versus Amazon Studios story, the Love Zone?
Yeah. I'm amused. So in real life, Maurice Watts is a person. Yeah. He's a radio personality, host, quote, the Love Zone since the early 1980s, a radio show. He owns the federally registered trademark. I'm not exactly sure what all that mark encompasses, I guess, live performances. Amazon Studios and Paramount Television Studios are producers of the streaming series Cross on Amazon Prime Video, which is the Alex Cross series based on the books, I think. Anyway, Watts has his the Love Zone radio show. He obviously has a very deep baritone voice and has substantial goodwill, especially within the Black American communities. He owns the trademark, the Love Zone. In an episode of Cross, a fictional DJ who has a very similar baritone voice, hosts a romantic call-in show called the Love Zone. The character Alex Cross is listening to the show. He calls in, requests a song. It was his wedding anniversary for his deceased wife, and so anyway, it's around this. The theme of this episode is built around that and him calling into the show. Uh, Watts starts getting high fives from his friends and family saying, "Hey, great job on being part of this Amazon Paramount Alex Cross TV show," to which he then sued for violation of the Lanham Act in addition to his state law trademark claims. So, post uh, the Jack Daniels dog toy litigation, where the Supreme Court said the first thing you've got to do when someone brings a claim that you've, for a third party trademark used in a creative work, is you need to decide if it was used as a source identifier. I looked at the opinion and they didn't decide that first. They decided it second. But okay. So the court jumped immediately to analyzing Rogers v. Grimaldi. And the first prong was artistic relevance. Was there artistic relevance to using the Love Zone in connection with a fictional radio show on a fictional episode of TV? And they said it was, because there was this emotional anchor between the main character and his wife, and that's why it had artistic relevance to use this name for the show. The second factor was whether or not the use of the name The Love Zone was misleading. And the court went through the Polaroid factors, which are relevant in this district in New York, as opposed to if you're in a DuPont factor state or a sleek craft state or district. And that is where they analyzed the trademark infringement portion of it, going through all of those factors. But the court said the proper comparison is not between the Love Zone within the series Cross and the Love Zone in reality, but just the Cross episode and the Love Zone. Because of this, even with the elements that could arguably be in favor of Watts, again being the strength of the trademark, the similarity of the marks, consumer confusion being one of those, which we know they had, the court said the creative nature of the use in Cross outweighed any actual confusion that was experienced. The court stated that, quote, common sense dictates that Rogers precludes the Lanham Act claim. Of course, Watts did attempt to argue the Jack Daniels Bad Spaniels case, which would indicate Rogers would not apply in this instance, but the court summarily dismissed the argument due to the format of the fictional Love Zone not resembling the actual Love Zone at all. Court decided Lanham Act claims should be dismissed with prejudice. State law claims were also dismissed. Given the federal claims were dismissed due to Rogers, that's why the state law claims were dismissed. I don't know. Was the mark used as a source identifier within the program? I mean, why else would they have picked it and the deep baritone voice if they didn't? And if I recall correctly, the character of Alex Cross in this version is African American.
Yeah. Yeah.
I mean, why did they pick it if it wasn't to invoke that?
Well, why did Netflix pick the Waves for the LA basketball team? This is a similar.
I know there's a lot of Netflix conversations out there. But does it make maybe because it's not the title of the show?
Yeah.
It's within it. I mean, I guess I could, putting on my other hat, to argue, even if it was used as a source identifier, was it nominative? Could it be fair use? Any program talking about love could have been, but they could have called it something else.
Yeah, well, and actually,
They could have called it the Love Factor. They didn't have to call it the Love Zone.
well, and I just actually went online and looked quickly while we were talking about the trademark registration, and I dare say that if you're thinking about making a fictional radio show about love, there are lots of possible titles, and it wouldn't be at all surprising to me if the first 10 that you decided on for the show were already registered as trademarks. Love Zone, Love Factor, Love Territory, the Love Show, the Love whatever. So, that's one of those words that's going to show up over and over and over again. So is it really incumbent on the creators of TV shows? I think this is another case telling us, no, it's not incumbent on them to do a trademark search before mentioning a fictional show. Did they, well, here we have the actual show hosted by an African-American deep-voiced man, chocolate voice kind of a thing. Maybe they did know about the Love Zone show, and they just thought, oh, whatever. And I think the court is deciding, yeah, doesn't matter. They don't have to get permission in this instance. If I'm Watts, I'm thinking that's horrible. They're basically appropriating my persona, if not my actual name, and putting it into this TV show.
Maybe he should have filed under that. Right, a publicity claim.
Well, depends where he lives, right?
Which I know, it depends on where you live, and I think there were state law claims which could have encompassed a right of publicity claim. Okay.
And those were dismissed.
I don't even know if this radio show is still on the air, and you've already said you don't listen to radio, so you don't know either. Delilah.
Yeah.
Do you think they could have called a radio show Delilah and had a female voice and that not... maybe his show's just not famous enough?
I don't know. And what if they called it Lila instead of Delilah? It still evokes the idea.
The same thing.
Right. So, at least for now, that we have a lot of trial court rulings on this. I don't think the Pepperdine case against Netflix went beyond a trial court.
It did not.
Either. We may see something before too long. I don't think Pepperdine has decided not to file yet, not to appeal. This may be another one of those. So we'll see who has the the financial and stomach for it to pursue things in an appeal. But anyway, so that is it for our rundown of shows this month, I should say. And we want to say thank you, as always, to you, our loyal listeners, for spending your time with us. And if you have feedback, we really do hope you'll leave it for us using that voice widget or sending us an email. Go to entertainmentlawupdate.com or an email, entertainmentlawupdate@gmail.com. And Tamara, tell folks how they can find you.
Yeah, you can find me at harperandbates.com, createprotect.com. Most social media, I'm at Tamera Bennett.
And from Los Angeles, California, I'm Gordon Firemark. You can find me at firemark.com. The email address, gfiremark@firemark.com. Most social media, it's gfiremark. And let's say thank you to our crack team of volunteer contributors. We have John Janasek, our managing editor, Charles Thorne, Alexis Allen, and Lauren Malone, all on the team and contributing to this episode. And if you are interested in joining the fun here as part of our little family of Entertainment Law Update contributors, please reach out to us. entertainmentlawupdate@gmail.com is the way. And I meant to say that's a wrap for this episode. That's showbiz.